Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the Fourth District of Texas is now open pursuant to call.
You may be seated. Good morning and welcome to the Fourth Court of Appeals. Court call 04-2400-729 CV Jesus Jr. Garcia versus San Miguel Electric Cooperative. I could get announcements from the parties, please.
Misty Hadaway-Kane on behalf of appellant Jesus Jr. Garcia.
Perfect.
Kyle Steinberger and Nicole Thornton for the appellate.
All right. Very well. As you know, you have 20 minutes. You'll have 20 minutes, San Miguel, and then another 10 for you.
Your Honor, I would like to reserve 4 minutes for rebuttal, please. And I'm going to lower the mic, but hopefully you can see me, but more importantly, hear me today.
I can appreciate the lowering of the mic, trust me.
I appreciate that. Good morning and may it please the court. My name is Misty Hadaway-Kane, along with trial lawyers Ryan McLeod and Brett Hargis. We represent the appellant, Jesus Garcia. In my time before the court, I will present argument regarding why we believe the trial court erred in granting summary judgment in this case. There are 2 global reasons why we believe the trial court erred in granting summary judgment. First, appellant believes that Chapter 95 does not apply in this case, or at a minimum, genuine issues of material fact exist as to whether it applies. Number 2, genuine issues of material fact exist as to whether or not the exception to Chapter 95, specifically 95.003, would apply. There are a few facts that are relevant to the analysis that I'd like to highlight for the court. If the court would require more facts, I'm happy to go into even greater detail. But what is undisputed is that Jesus Garcia was working for his employer on a project for San Miguel. Originally, the project began working solely on 4 cooling units. It was later, just 48 hours before the incident, that the cooling unit that Mr. Garcia was working in was added to the scope of work. And it was added to the scope of work because while making repairs on a nearby unit, Mr. Garcia's employer accidentally cut into the P unit, and that's why those repairs had to be made. What is undisputed, however, is that nowhere within the scope of work for any of the units was there a task charge to Mr. Garcia or anyone at his employer to make repairs to the scaffolding, the catwalk scaffolding. And it's that catwalk scaffolding that was in such a state of disrepair that when Mr. Garcia was leaving for his lunch break, so he had already stopped his work for the morning, was leaving for his lunch break, was following the policies that San Miguel put in place to tie on. He got to the point where he was allowed under San Miguel policy to detach, that he detached and took a step forward, and the scaffolding, the metal scaffolding, completely collapsed, and he fell 54 feet to some pretty substantial injuries.
Can I ask you a question?
Sure.
Was Mr. Garcia using the catwalk to access his work, or was he exiting the cooling tower?
He was exiting, Your Honor. So he had been in his cooling unit, and to be clear, what Mr. Garcia was doing was removing some debridement and some wood. He was not doing any metal work. And again, nothing in the summary judgment record indicates that there was any work that was being done on the catwalk. And separately, nothing.
But let me go to that, because you're talking about the actual repairs that were within the scope of the work, but also in the contract, wasn't there a blanket requirement that in order to do the work, that the contractor was responsible for inspecting the safety of anything that they might have to use in doing the work?
Anything that was required to use, like a tool to use the work.
Enter or exit the tower, anything that they might.
The record is not clear on any burden placed upon the contractor or Mr. Garcia to inspect the scaffolding and the catwalk to enter the premises. And that
There was something in the contract that actually said every day they have to inspect for safety, for ingress and egress, and also that as they were doing their work, they had to be inspecting for additional repairs.
Absolutely a duty to look for additional repairs, but what the contract did specify is that there was a San Miguel contractor overseer who retained the inspection right. And if you look at the record at page 360, it spells out the responsibilities, and it's a SMEC, S-M-E-C was the abbreviation for it, but it was the San Miguel Electrical Cooperative Contractor Representative. And so it was a San Miguel entity who interfaced with the employer, Mr. Garcia's employer, who retained the duty and the obligation to inspect, including overseeing to ensure that,
Who is the SMEC contractor?
no, the SMEC contractor is, I don't have, the name is not identified. The only name that was identified with regard to San Miguel, who testified before summary judgment, was Eric Hoffman. And he's an engineer for San Miguel, but the identity of the SMEC contract representative is not in the summary judgment record.
So wouldn't Garcia's employer be the SMEC contractor that they're referencing? Because they wouldn't be referencing SMEC or an employee of SMEC. They'd be representing the contractors they're hiring to inspect and repair.
Well, except the record at 220 provides that all contractors, their subcontractors, and their employees are expected to comply with SMEC's safety program, and SMEC specifically retains the right to inspect on an ongoing basis and audit compliance with that ongoing basis. And SMEC utilized, and I'm using SMEC as San Miguel Electric Cooperative, SMEC utilized this individual to conduct those inspections. And so when you look at, I'm sorry.
You're saying, you just said the right to inspect, which I'm going to kind of piggyback onto what Justice Brissett is asking. Ultimately, was Midwest responsible for doing the daily inspection before Midwest subcontractors started their work or Midwest employees started their work? And I think that's the question you're
Yes.
asking.
And I apologize if I wasn't answering.
There's two prongs.
Yes.
Was Midwest responsible in the contract to do the daily inspection before they did their work? And two, while they were doing the work, weren't they had the ongoing duty to inspect for additional repairs?
I 100% agree as to number two. As to number one, both Midwest, so MWTC, and SMEC, so it's an alphabet soup.
SMEC contractor.
Well, except, Your Honor, when you look at the actual language of the contract between SMEC and Garcia's employer, NWTC, you'll see that it was an individual that SMEC, that San Miguel Electric Cooperative retained, who would oversee. And so it is it's not a NWTC individual that was then going to ensure compliance with SMEC's work. It was a SMEC individual that was ensuring the contractor's compliance. And that right was retained in the contract at the
Okay,
record.
so you're saying in addition to Midwest having its own inspection duties relating to what work it was doing, there was also another contractor that would oversee compliance.
Well, not a contractor. It was San Miguel would oversee compliance. And so, and Your Honor, it's because of that second prong that you pointed out. That's how the scope of work expanded to even cover cooling tower P. Because while performing the duties in the adjacent cooling tower under the contract, work cut into cooling tower P. And it's because his employer was doing what it was required to do under the contract. They reported the fact there was this damage to the other cooling tower, which was never originally going to be in the scope of work. And that scope of work was then expanded.
Would you agree that had he recognized that the scaffolding needed repair before he got on it, that would have needed to be reported to SMEC for repair, for additional repair?
I believe if anyone had reported it to SMEC, or SMEC.
I'm not asking about SMEC, I'm asking about him. Under the contract, while he was doing his work, you agreed that he had the ongoing duty to inspect for additional repairs. So does that mean that had he inspected the catwalk before he placed his weight on it and determined that it was corroded and needed repair, he would have needed to report that for additional repair?
I will agree with that, but I will also state, Your Honor, that nothing within the contract or Texas law would absolve San Miguel Electric Cooperative of likewise making certain that the premises that it has opened up to these invitees.
This is not about absolving SMEC. This is about determining the burden of proof.
Well, yes,
Chapter 95 applies, right?
Yes, Your Honor. And we believe that when you look at Chapter 95, because the cooling tower is not what injured, it isn't the condition of the cooling tower that has the causal connection to the actual injuries that Mr. Garcia suffered. It was the scaffolding that he utilized to exit for lunch.
Scaffolding attached to the tower?
It absolutely was. But when you look at the case law, because it did not affect the condition of being, so it was absolutely removable and did not prevent access or use of cooling tower B, that is why Chapter 95 doesn't apply. Because the dangerous condition was not to the improvement that was being worked upon. And the scaffolding and the lack of scaffolding, because after the incident made the basis of this lawsuit, that scaffolding was removed and it was not replaced. And so it did not affect the ability for NWTC or anyone to ingress, egress the cooling tower to make the repairs that Mr. Garcia's employer was conducting. And so that's why, Your Honor, when we look at the litany of cases that look at this condition of being, as well as the applicability of Chapter 95, we see, for example, the case out of Houston. And in that case, the contractor was tasked to make a repair to the air conditioning units. And the air conditioning unit was on the roof. The roof was in a state of disrepair. The roof caved in, he fell, collapsed, and unfortunately, the man was injured. The court found that Chapter 95 didn't apply because he was tasked with making repairs to the air conditioning unit. And the dangerous condition of the air conditioning unit did not affect the state of being of the roof. Likewise, the disrepair and corrosion and defective condition of the scaffolding on the catwalk did not affect the condition of being cooling unit P, and it did not prevent anyone else from accessing and working in cooling unit P after the accident made the basis of this lawsuit.
But what if in that Houston case, in addition to repairing the air conditioning, they had an ongoing duty to inspect the roof on which they were going to have to place their weight in order to access the air conditioning? If they had an ongoing duty to inspect for additional repairs, and they would have had a duty to report the need to repair the air conditioning, would you think that would be a different case?
Well, I think it would depend, Your Honor, because at the end of the day, the dangerous condition that injured the individual wasn't the roof, it was the AC. And so I would argue, Your Honor, there is an ongoing duty for Mr. Garcia and his employer to inspect cooling unit P.
Well, the Houston case was based upon the scope of the improvement, and the scope of the improvement in that case was the air conditioning, because there was nothing said about anything else other than the air conditioning in the contract. What I'm saying here is let's expand that contract and let's put an ongoing duty to repair and inspect for additional repairs as they access the roof in order to access the air conditioning. If they had ongoing duty to inspect, not just the air conditioning, but what they had to do to access the air conditioning, would that be a different case?
That would be a different case, Your Honor. And in this instance, the ongoing duty to inspect the language did not expand, or at a minimum, a genuine issue of material fact exists as to whether it expands to your ability to ingress and egress cooling unit P. I would fully agree with you. If Mr. Garcia had been injured walking into cooling unit P by a condition in cooling unit P, very different case, more in line with the example you just provided.
He might not have been walking into, he was trying to get out of. Why is that a distinction?
Well, it's a distinction, Your Honor, because he was leaving work for the morning, and it's unclear if he was actually going to come back after a lunch break. And so when you look at the cases, when we look at Covarrubias, when we look at Wall, when we look at Weekly Homes, there's some very clear distinctions between those cases. The case law seems to fall if you are entering the work unit, right, where you fall within the improvement and you fall within the first subsection of Chapter 95. If you are ingressing, then you are accessing, and courts have interpreted that 95 to apply.
Do you really think the courts would say if you're coming in to access it, you're covered, but if you're exiting, it's not? What's the distinction between those two?
I think the duty is different. I think the duty is absolutely different when you are an invitee and you're coming into a unit and there's a dangerous condition that you are in cooling unit P that is there. Okay. But he had exited cooling unit P. And so the scaffolding is condition that did not affect the status of being of cooling unit B.
Is the scaffolding within the cooling cell of B?
It is on the excess, it's on the outside so that you could exit. He was going to take the catwalk down to a ladder to literally be on the ground outside of the unit.
So the catwalk was outside the cell tower?
Yes, Your Honor, and the proximity of the catwalk to where he was actually working is what's at issue. And Your Honor, when you look at the cases, you have to look at where the individual was actually tasked with working. And so I will fully agree that if Mr. Garcia had been injured in cooling unit P, it's a very different analysis. But in this instance, he was injured when scaffolding, completely unrelated to the scope of work, collapsed.
What are you referring to in the record when you say the catwalk was outside the cell tower?
When we look at, I can direct you, hold on, it's in my facts. We can look at, well, we can look first at the proposal and the scope of the proposal as to the scope of work that was being accomplished, number one. And then we can look at the pictures of the scaffolding on the outside, that's at Clerk's Record 353. And then we can look at the distance that from where he was working, because recall he was doing some woodwork to support some of the repairs that were being done by his coworkers. And so there isn't a map per se, Your Honor, if that's what you're looking for.
You're saying the picture on Clerk's Record 353 will show us the catwalk outside the tower?
Yes, Your Honor, it absolutely will. And I have little, they're small, but I do have little snippets of the scaffolding outside of cooling unit P in my brief at page 9. And so you can see that the scaffolding is absolutely on the outside of the cooling tower, and within the cooling tower is where the work was being performed. But turning to the second unit, or the second issue, which is this exception, the error here is just a basic error where there is a presumption that Chapter 95 applies. There is zero evidence or argument in the trial court by San Miguel addressing the fact that the condition was not cooling unit P and what role, if any, the catwalk played on the condition and the state of being of cooling unit P. That was completely devoid and not even addressed in the trial court. But then when we look to the second issue, which is, do we fall within Chapter 95.003, there are ample genuine issues of material fact on those two issues, Your Honor. The first issue being the retained control and exercise control. Your Honor, I don't have to establish by preponderance of the evidence that they retained control if they exercise it. I have to raise a genuine issue of material fact. A great bit of the briefing that occurred in the trial court as well as in this court really focused on a comparison of the facts of this case to the Dow case from the Supreme Court. But the language in the Dow case was very different from the contract language here. The contract language here, there was a retention of control, whereas the language in Dow was a disclaimer of control. And so, Your Honor, we argued in the trial court that the retention of control and those two provisions I mentioned earlier in the contract were sufficient to raise a genuine issue of material fact that should have warranted the denial of summary judgment. Because to succeed, the defendant was required to conclusively establish both that there was no evidence of control or a right of control or exercise of control, and that there was no actual knowledge. There was just a presumption that there was no control. There was just a presumption that there was no actual knowledge.
Would they have to prove both of those conclusively or just one?
Your Honor, to succeed on both, for us as the plaintiff to succeed on both, we would have to show both. For the traditional summary judgment to be granted, they would only have to negate one. While our burden at trial would be to show applicability by preponderance of the evidence of both of those conditions, because there is a conjunctive between subparagraph 1 and 2. To succeed, they needed only 2, devoid of 1. But when we look at the evidence, Your Honor, there is ample genuine issues of material fact as to both. I see that I have 2 minutes left. I don't think that the time adjusted for my reservation. May I finish this little argument and then reserve the balance?
Sure.
And so what I would direct the court to is to do a comparison of the language in the contract at Dow and the language here at the clerk's record at 220 and the clerk's record at 360 to 361. the appellee, San Miguel, not only required compliance, monitored compliance, but did these routine inspections. And so, Your Honor, we believe that there is a genuine issue of material fact as to that element. In addition, as to actual knowledge, it was their burden to show that they had no actual knowledge, and they had to conclusively establish that they had no actual knowledge. And that simply is not the case. There was some letter briefing, post briefing on this issue. There was the Wilder case that the appellee brought to the court's attention. I did provide the court a letter brief distinguishing Wilder, but the one thing that I really want to apprise the court of when it's putting together its opinion is to look at the cases where there is a jury verdict and look at the cases where there is a summary judgment, because the burden in this case, as y'all well know, is significantly different. Our burden is to raise a genuine issue of material fact as to the applicability of Chapter 95 and as to the applicability of this exception. We believe that we did so, and the trial court ignored those genuine issues of material fact, simply assuming that Chapter 95 applied. I'd like to reserve the balance, Your Honors. Thank you very much.
So just real quick, I just want to make sure you had asked us to give you 4 minutes. Did you want those 4 minutes right now to continue to discuss actual knowledge? And then we will just give you the 6 minutes at the end. And I'll certainly give you extra time as well if you need it. I'll give San Miguel that extra time. I just want to make sure that we didn't interrupt your argument, but I guess the timer interrupted your argument.
Your Honor, I'm happy to continue discussing actual knowledge and the evidence in the record that raises a genuine issue of material fact as to that actual knowledge. I can point the court to Eric Halfman, who is that engineer that admitted knowledge of the humidity and whatnot in this area. I can do that now, or I can do that in my rebuttal.
But they did reserve your time.
Oh, well, then I have 36 seconds. And so I'm going to use that 36 seconds to point you specifically to Mr. Halfman's testimony. There was some argument in the appellee's brief that we are trying to change and lower the burden to knew or should have known, which was common law before Chapter 95 applies. That is not the position being taken by appellant. The position being taken by appellant is that we can show through circumstantial evidence, and that has not been destroyed, that we can show through circumstantial evidence that they knew of the dangerous condition with the scaffolding and the catwalk. So we can do that 2 ways. First off, the pre-work inspection that was conducted by San Miguel that spurred the need for Mr. Garcia's client to come out and perform these services was an acknowledgement in these units that they were in very poor condition, including Unit P, which again was not in the original scope of work. In addition, there is the testimony from Eric Halfman about the high humidity, the corrosion, and the the defects that were developing because of this corrosion and high humidity. And because of those 2 issues, Your Honor, we believe that raised, it was circumstantial evidence, particularly the inspection report, that raised a genuine issue of material fact as to whether or not San Miguel knew of the dangerous condition on this catwalk. And so I'm happy to discuss in greater detail in my rebuttal, but that's what I did want to wrap up in my 36 seconds.
Okay, I just have one question for you then before you step away, and I will give you the extra time. So I appreciate the genuine issue of material fact, but I'm not so sure that I'm appreciating constructive knowledge versus actual knowledge when we talk about these reports that were generated to discuss the humidity and the potential corrosion. So help me appreciate that a little bit more.
So we know this fact. We know that San Miguel had conducted this inspection to assess the need for the repair work and the renovated work that was then the subject of the contract with Mr. Garcia's employer. So we know that San Miguel contracted and obtained this inspection that did an overall analysis of these various cooling units, including cooling unit P. I cannot point you to a principal who received the report, but we know that San Miguel itself promulgated that report and had that report prepared. And based upon that report, the decision was made by San Miguel to retain MWTC to do this work and to do the repair work and to do the replacement of the woodwork and the debris bin and whatnot, like what Mr. Garcia was doing. And so we believe that because San Miguel tasked for this inspection to be conducted, had this inspection conducted across all of its units, not just the 4 in the original scope of work, but across all of its unit, including cooling unit P, that it was aware that there was a very poor condition in this area, and yet at the outset didn't find cooling unit P to be sufficient to warrant the reconstruction and the renovation work, but then because of the injury conducted through this contract, then expanded it. And then when you look at the knowledge that the engineers on the ground for San Miguel have of the fact that these conditions in these rafters have high humidity, we believe that those two important facts are circumstantial evidence of actual knowledge. We are not arguing constructive knowledge. That is not the test. So hopefully that helps.
Thank you.
Thank you.
If we could just give San Miguel 3 extra minutes, please. Thank you.
May it please the court. Mr. Garcia says that he's not arguing constructive knowledge, but that's exactly what he's arguing. Because the thrust of the actual knowledge argument is because conditions existed that had San Miguel investigated might have led it to identify a condition on the catwalk, that it's responsible for that condition on the catwalk. That is a quintessential case of constructive knowledge. What Chapter 95 requires is actual knowledge. In the 2020 report, which was prepared by Midwest, Mr. Garcia's employer, it does say very poor condition with respect to cell P. But what City of Keller teaches us is that we can't pluck random statements out of isolation to create fact questions when in context, they mean the opposite. And if you review that report in full, it makes several very specific recommendations for immediate work. All have to do with timber. None of them have to do with the metal grating on the catwalk in cell P, or any other cell for that matter. For that reason, and for many other reasons that I'll discuss, the trial court's judgment in this premises liability case rests comfortably on Chapter 95's foundations. And that's true for 2 reasons that I'll discuss today. First, the evidence conclusively proves that Chapter 95 applies to Mr. Garcia's claims. His claims arise from the condition of the improvement, the cooling tower, he was on San Miguel's property to repair.
Was the catwalk inside or outside the cell tower?
It was absolutely inside of it, Your Honor. If you look at the photos on page 207, you can actually see that it's bolted into the structure. And what Mr. Garcia was actually doing was stepping off the platform or the area where he was working to access that catwalk so he could go up, out, and down. Because the way this cooling tower was designed, and when I say cooling tower, that actually means the entire 600-foot multi-cell tower.
So I want to get back to this. So this should be really clear. There shouldn't be any dispute as to whether it's inside or outside. Where was the man found when he fell 54 feet? Was he outside the tower or was he inside the tower?
He was inside the tower, Your Honor.
And where would I find that in the record?
In the Midwest post-accident report, and that's at 201 to, I believe, 213, thereabouts. And that lays out very clearly what happened with respect to this accident.
Let me ask you, can the repairs Midwest was hired to perform still be done now that the catwalk is gone?
I believe they could be, Your Honor, but that's not the test for Chapter 95's applicability. Because there are really 2 ways that you can kick in as a property owner to Chapter 95's protections. One is if the catwalk is part of the improvement. And INEOS tells us that we don't look at the Lego house as a collection of bricks. We look at it as a fully built Lego house. And here the catwalk is snapped in, it's bolted in to the broader structure of the cooling tower. But even if it's not, and we're looking at a Los Compadres or a Weekly Homes proximity situation, all that's required for a condition that is in proximity to an improvement to constitute a condition of that improvement is if by reason of its proximity, it increases the risk of harm to the worker. So for example, in Los Compadres, it's not necessary for the workers to hit the power line with the rebar. And the evidence there actually established that they got the rebar pretty significantly into the pillar before they actually made contact. So they never had to touch the power line. What made the power line a condition of the improvement that they were building was its proximity and the increased risk of harm. And that's the same situation we have here, where Mr. Garcia is working inside the cooling tower. He and his crew decide they want to go up and out to store their gear instead of climbing down before they go to lunch. They step onto the catwalk. Mr. Garcia unclips his harness. The catwalk collapses. So we have that sequential bang bang, more or less, that Los Compadres and Weekly Homes contemplate, even if the catwalk isn't, strictly speaking, part of the improvement.
Is your summary, I'm sorry, go ahead. Is your motion for summary judgment limited to the proximity argument instead of the fact that it might be part of the improvement being repaired?
We make both, Your Honor.
Okay.
Okay, so my question for you is, if we're saying that it's part of the improvement, and I'll just put proximity aside, I'm reading your letter brief, and these are your words. San Miguel had no reason to know that Garcia would use the catwalk. No reason to know that. So what does that do for my analysis in deciding whether or not the catwalk is part of the improvement, if those are your words?
Your Honor, it doesn't affect the analysis when we're determining whether it's part of the improvement, because the improvement question really is, when we look at this, was it affixed to the realty with an intent to make it permanent? That's what determines whether something is an improvement or not. The reason that San Miguel had no reason to know that he was going to use the catwalk is because San Miguel had no control over how he got up and down. That was his responsibility. That was his employer's responsibility to make that decision. And Mr. Garcia actually testifies that the days before this fall, when he was working in Cell P, he didn't use the catwalk. He climbed up and down the way he got up the morning of the accident.
Is the catwalk permanent if you can remove it?
It absolutely is, Your Honor, because as Sanier explains, when we look at whether something is an improvement, we look at the intent when it's attached. We don't look at whether it can be removed.
But whether something is an improvement is a different question about whether it is the improvement being repaired in this case, right? So how does, because I feel like this contract had two aspects. It was repair and an ongoing inspection. So how does that impact how we are supposed to construe what the improvement was in this case?
Your Honor, the statute tells us how we determine what the improvement is in this case. His claims must arise from the condition of the improvement where Mr. Garcia was modifying the improvement. And what the word where tells us is the relationship between the condition that causes his injury and the condition that he's on the property to work on. So in other words, we look at the back half of the statute to say, is this the improvement that the statute applies to? And in this case, it does, because the catwalk is, again, bolted into the broader structure of the cooling tower.
But he wasn't repairing the whole cooling tower. He was repairing the wooden structures within the cooling tower, right?
That's true, Your Honor. It doesn't matter. Under INEOS and cases that follow it, it doesn't matter whether your work, the object of your work, is what causes the injury. So in INEOS, we have the gas leak hundreds of feet away on this large connected pipeline system. And it's that explosion that injures the man who's changing a gasket, or who's changing a valve. It's not his work that causes the injury. It's the gas leak.
Okay, but then I need you to reconcile INEOS, like 2016 weekly, last year. Because I think over those years, you've seen sort of a broad interpretation of improvement, and it's narrowed. So reconcile that argument with weekly. Because I think you'd have to agree with me that the cases are showing, that it was pretty broad and that works in 2016. Does it work today?
Your Honor, they address two different issues. So Ineos talks about the situation where everything is snapped together, where it all constitutes the same improvement. What Weekly Homes discusses or addresses is the situation where something is not snapped onto the improvement, but it's close enough to the improvement that it constitutes a condition of it. So in other words, Ineos is the case you look to say this conglomeration of things that are interconnected are a singular improvement. If you can't do that, you look at Weekly Homes to say, does the proximity of this thing that is not technically part of the improvement nonetheless constitute a condition of it? So they address really two different pathways to Chapter 95's applicability. And under the facts of this case, Chapter 95 does apply, because notwithstanding whether Mr. Garcia had decided he wanted to go to lunch or not, his claims arise from the condition of the cooling tower, where this catwalk was bolted into on the interior. And that is where he was on San Miguel's property to work. So under the plain language of the statute, under the facts that should not be disputable, Chapter 95 applies on its face to his claims. That means Section 95.03 provides the exclusive mechanism for him to recover. And on this summary judgment record, the trial court correctly found that no reasonable jury could conclude that he can prove either exception. Let's start with control. Justice Brissett, you keyed in on that. The contract between Midwest and San Miguel makes very clear that it's Midwest's obligation as part of its scope of work to do not only construction management, but safety. And in the bid proposal that Midwest submitted, they made very clear to San Miguel that the first day in every cell, Midwest was going to inspect it for weak tie-off points and potential risk areas. It was Midwest that assumed that contractual control over the safety issue. And that's true notwithstanding the relatively benign language in the San Miguel safety policy. Because really, if you cut to its core, what that language says is that San Miguel has the right to stop and start work. And that under the statute, both by its plain terms and under the common law, which the statute essentially codified, that's not enough. The right to stop and start work is not the type of control necessary to impose liability on the owner.
Can you address counsel's statement about SMEC contractor?
Your Honor, the SMEC contract representative is a San Miguel person, I'll say. I also don't know who it is in this context, but it, again, doesn't affect the Chapter 95 analysis in this case, because all that San Miguel contractor representative does, or the only power he holds, is the generic power to stop and start work.
I thought she said that he had the option to inspect and monitor and oversee or supervise compliance.
It's the same general umbrella, Your Honor. And if you look at 95.031, it explicitly excludes that type of control from the statute's reach. It says other than the right to order the work to start or stop or to inspect progress or receive reports. So essentially all the San Miguel policy does, the only power that the San Miguel contractor representative has is that power. He can tell you to stop doing things if you're doing things unsafely, and he has the right to monitor and supervise the work and inspect the work. That's not the type of control that's necessary for a 95.003 claim. With respect to actual control, There's similarly no evidence in the record from which a reasonable jury could conclude that San Miguel had actual control over Mr. Garcia's work. Because under these circumstances, as Mr. Garcia testified in his deposition, what he did in that tower was between him and Midwest. He shows up in the morning for his shift that Midwest scheduled for him. He attends a Midwest-led toolbox talk where they discuss the risks of the work that day. He uses Midwest-provided safety gear. He goes up the tower using safety tie-off points that Midwest identified, and he conducts the work that Midwest told him to conduct. San Miguel didn't even have someone on site. So when we're looking at this from the context of actual control, there's simply no evidence of it. No reasonable fact finder could conclude that San Miguel ever had the control or usurped the control necessary for the exception to apply. Irrespective of control, though, actual knowledge disposes of the claims with equal force. And as I discussed at the beginning, actual knowledge means something different than you should have looked at these facts and understood that something might have been wrong or was wrong. That's quintessential constructive knowledge. It's not enough for actual knowledge that you knew something might deteriorate over time. It's not enough for actual knowledge that you knew the conditions were conducive to a dangerous condition developing. What actual knowledge requires is that San Miguel know when the accident happens that the walkway is so rusted through that it constitutes an unreasonably dangerous condition. Your Honors, San Miguel, before this accident happened, never sent anyone up to the walkway. It wasn't qualified to do that. Its employees weren't qualified to do that. It relied on folks like Midwest and the people that Midwest trained to do that specialized work for them. It relied on contractors, as it should have, to conduct this specialized work. And as I said, it's absolutely true that this 2020 Midwest inspection report identifies the structure of cell P as being in poor condition. I agree. As I said, that's not enough. Because when you read that report in context, very poor condition, it's talking about the wood. It's not talking about the metal. It's not even talking about methods of ingress and egress. Because if you look elsewhere in that report, you can see where Midwest actually identified areas on the top fan deck where there were handrail issues. And they actually noted where they found the stairway or handrails needed to be addressed.
And how did they find those things to identify for repair? Did San Miguel do that, or did another contractor do that?
Midwest did that, Your Honor.
Okay.
Midwest, Mr. Garcia's employer, is brought out by San Miguel to conduct this inspection. Midwest identifies what it says are the deficiencies, and that ultimately prompts the work that Mr. Garcia is doing when this accident happens.
And so you're saying if Midwest didn't tell them about the catwalk, they don't know about the catwalk?
That's right, Your Honor, and there's no reason, no basis for them to have inferred that the catwalk was itself an unreasonably dangerous condition, not just in poor condition, but unreasonably dangerous, so that it posed an unreasonable risk of harm to someone simply because they received this global statement that the structure is in poor condition. It's like if you go to a mechanic, Your Honors, and they say, your tires are in poor shape, let's replace the front two. That doesn't mean I have actual knowledge that the back one has bad tread. Because when we consider that in context, a reasonable person understands that as a statement about the front two tires. And that's something analogous to what we have here, where Midwest identifies specifically deficient areas that it thinks need immediate improvement, and then makes recommendations for the future. It's completely silent on the catwalk.
This poses an interesting question, and I'm wondering if y'all have looked for any cases in regards to this, because, You have a situation where a company hires a contractor to make something safe. And they're arguing that because it was unsafe, the company is liable. Is there anything in that context where the contractor is there to make things safe?
Your Honor, that's exactly the situation that 95 applies to. That's why the legislature enacted this statute, because they recognize that when a property owner needs to hire a specialist to come out and repair something, and again, the statute requires that the improvement ultimately be modified in some way. So the legislature recognized that when an owner hires a contractor to come do that, there's a certain, I'll say, risk reward, because the contractor knows that they're coming out to repair something. They're coming out to modify something. So it doesn't make sense from a policy perspective for them to be able to turn around and say, aha, owner, look at this unreasonably dangerous condition, even though that's the condition they were out there to repair. And that's why 95003 has those very specific predicates to recovery under the statute, the control and actual knowledge. Because that's the risk part of it, is if I exercise that control, if I have that actual knowledge, then it's not necessarily as repugnant to the purpose of the statute.
Mhm.
So on these facts, Your Honor, this is exactly the situation that the statute was intended to apply to. If there are no other questions?
I may have a couple, just one second.
Yes, Your Honor.
Okay, I just want to be clear, just as a follow-up to what Justice Brissett was just asking you, because my notes reflect that Midwest is tasked to change out the 2x4s, right? So if that's their task, I just want to make sure I'm appreciating how that expands to include what you're suggesting is the entire improvement, to include the catwalk. So if you'll explain that to me, I'd appreciate it.
Yeah, absolutely, Your Honor. So if we look at the scope of work, the scope of work for Midwest is not just changing out the 2x4s. It's actually a renovation, more or less, of the interior structure of these specifically identified cells. So it's not just changing out wood. That's what Mr. Garcia was doing when this accident happened. But before that, he was doing things like changing out drift panels, which they catch large water droplets, and it's an environmental pollution deterrent. He's changing out drift panels. He's doing other things besides just changing out the 2x4s. But at its core, Your Honor, this goes back to Ineos, and it goes back even further to Abudahun. It's not necessary that my work or that the object of my work be what causes my injuries. The focus is on the connection between the improvement, which on our facts is the entire cooling tower, and the injuries.
That goes to an interesting question. Is the improvement that the contractor is tasked with improving, or is it the improvement that the employee is working on at the time?
They would be the same thing, Your Honor.
Not necessarily. If you've got 10 employees, you've got 10 people doing 10 different things, and they might be eating an elephant one bite at a time, right? So do we look at the contract to determine the scope of the improvement, or do we look at what this employee was tasked with on this day?
We look at all of the facts and circumstances, Your Honor, but they may be eating the elephant one bite at a time. They're still eating the same elephant. So the way this statute really comes into play is, like in this case, the owner hires someone to come out for a project, to repair some improvement, to modify some improvement. It's up to the contractor, because they're the contractor, they're the experts, how that looks, how they assign people to do various tasks that fall under the umbrella of the work that they're on the property to do, modifying the improvement. So we don't perform this kind of hyper granular, what exactly were you doing? Because again, under Ineos, under Abudahun, the inquiry is not what were you doing? It's, is there a connection between your injuries and the improvement?
Thank you.
Thank you.
May it please the court, I have just a few issues that I want to bring to the court's attention. There are some additional indicia of it retained and actual control I would like to point the panel to. Specifically, not only was there that reservation as found in the clerk's record at 220 that all contractors were required to comply with the safety program, and then not only was there the SMEC contractor representative that would then overview, but the record also shows that MWTC and its employees were required to participate in San Miguel's training orientation and safety orientation before it could ever set foot inside any cooling unit, number one. San Miguel retains supervisory, that's also the clerk's record at 220. San Miguel also retains supervisory control by assuming responsibility for ensuring compliance, okay? And that is at 360. And then they also assumed the duty to make certain that all of the contractors were familiar with those hazards. So you've got two competing duties, Your Honor, and Justice Brissett, you were right out of the gate from the very beginning of there is a duty by NWTC to inspect where they're working. But that doesn't change what was assumed under the contract of the control that was retained and in fact exercised with this inspection process. The second thing that I want to talk about is this connection issue. And so Chapter 95 and every case that has examined Chapter 95 makes it very clear that there has to be an absolute connection and a link between the plaintiff's injuries and the condition, right? And so Justice Valenzuela, you astutely recognized that you have this issue in their letter brief where San Miguel is trying to have it both ways. They're trying to say that the catwalk in its state of disrepair and condition was part of cooling unit P. So basically they assumed the risk, they knew it when they were going into it, but we had absolutely no way we could have ever known of the state of disrepair. And so we should be absolved. And Your Honor, I think when you look at the case law interpreting Chapter 95 and the case law interpreting the exception, you can't really have it both ways. And in this instance, there's genuine issues of material fact, not only as to whether or not this scaffolding, which was not reattached to use, right? And there was the ability for all of the workers to ingress and egress cooling unit P without that scaffolding, okay? So there's a genuine issue of material fact of whether or not that improvement would even fall within the first paragraph of Chapter 95. But then there is this genuine issue of material fact regarding what knowledge, and we can use circumstantial evidence, that SMEC, that San Miguel actually had regarding that state of disrepair in the cooling unit. So if, let's take their position, the scaffolding is part of cooling unit 3, right? So Chapter 95 applies, and we're not looking at this as a detachable improvement. Well, we have an inspection report that specifically says cooling unit P is in very poor condition. And it is because of that condition and that report that SMEC hired NWTC to do this work. So if this scaffolding is part of the improvements, then we fall squarely within the genuine issue of material fact on this exception.
So let me ask you just to go back to the policy question. If SMEC hired a contractor because it was in poor repair and it was unsafe and needed repair, how can a contractor then hold SMEC liable for being injured as a result of the unsafe condition?
You asked a question.
Then you're gonna actually have companies hesitant to hire contractors to make things safe.
I recognize the concern that the policy question you are raising provides. So the way that you combat it is by adopting safety policies that prevent that danger from occurring. And in this instance, we have a root cause incident report that specifically identifies the fact that SMEC's safety policy of allowing employees to remove the tie-in, right? So remove the tie-in when they get onto certain scaffolding and certain catwalks. That was the cause of this incident, right? Because had he been tied on, the collapse would have still happened because it was in that defective, dangerous condition. But he would have been tied on to the unit, and then he would not have fallen 54 feet. So, Your Honor, the way that you combat this is what Chapter 95 allows. And so you adopt further safety policies to further protect you. But nothing within Chapter 95 or the case law allows a get out of jail free card to companies that are doing the right thing. I mean, and there isn't a case that's been published or unpublished where you've got an instance like this where an individual that was hired by a premises owner to make repairs was injured. And I'm not going to concede that it was while he was making repairs because that is undisputed. He was not. He was no longer performing work under the contract. His work had ended and he was leaving. But there is no get out of jail free card. What you do is you adopt these safety policies. And here, the safety policy allowed Jesus Garcia to disconnect when he hit that scaffolding, if it was a certain type of scaffolding, with the bridge and the handrail so he couldn't fall over. And so a safety policy should have been adopted to recognize the full state of this entire cooling unit and say you have to have automatic tie-on no matter what, and then have a long enough tie-on so that you can walk across the catwalk, walk down out to the unit, and take the ladder down to the ground so you could exit.
So you're saying the question of fact comes because in SMEC's safety course, they presented the policy that on this particular situation, you could be unhooked.
Correct. So the tie-in was required unless it was a specific catwalk or scaffolding that wasn't flat. So there was like a ribbon so you couldn't fall off, and there's a hand grip. And that makes sense.
But don't we have to read that in conjunction with the contract, which required the contractor to inspect the premises for anything that they would use during that day?
That's true, but you have to look at it within the contract where SMEC retained the right to train, in fact, required all these individuals to train, and wrote the very safety program that it required everyone to comply by. So the fact that SMEC retained control over safety, required compliance with safety, audited, monitored, and inspected safety, that's the problem. That is the problem. And Your Honors, there were genuine issues of material fact with regard to both of those subsections of 95.003. I recognize the court is struggling with how do we find this case in kind of the order of cases. And Justice Valenzuela, you pointed that out because we have weekly from 2024. And I kind of made like a little timeline of how we can look at these cases. So we have this court's I hope I'm not obliterating the name, Covarrubias decision, right? And in that instance, we have an inspector that was trying to access the work site. There was no dispute of where he was going fell within what he was going to be working on, right? So he's walking into this unit. He was injured walking into this unit because of a dangerous condition in this unit. That's Covarrubias, 95 applies. Then we go to, it's an Amarillo decision, the Wall versus Cypress H6, I think it is. And in that instance, it was a handyman who likewise was attempting to walk into the unit in which he was assigned to go work, okay? Then we have the Supreme Court's most recent David Weekley decision. And in that one, they were already engaging in the activity. And so we have an engagement, and that's also Ineos. Ineos was an engagement. They were already engaging in a work activity. Here, we fall off of kind of that timeline. We fall off of that timeline because there's a genuine issue of material fact regarding whether or not this scaffolding that was removed and the work continued was part of the unit in which he was working, number one. We have a genuine issue of material fact regarding whether or not the work that Jesus Garcia was performing, which was working in the upper risers and repairing the water filtering, right? So that the water would drip down. So he was a very different area of the unit that he is working in from the scaffolding. Then we also have the fact that he had ceased working in that improvement when he was taking the catwalk to walk out. So we have those genuine issues of material fact on this side of the scale. And then on the other side of the scale, we have the genuine issues of material fact regarding control, whether it was retained or exercised. I don't have to show both, and whether or not there was actual knowledge. And so, Your Honor, in the face of all of this, and in the face of these unanswered questions, We believe the trial court erred in granting summary judgment. There was an issue that was raised in the brief regarding Jesus Garcia's alleged failure to address duty for purposes of negligence or gross negligence. That in fact was briefed. It was briefed in the context of our 95003 argument, where we argued that by virtue of adopting the safety program, requiring compliance with this safety program, that a duty was adopted. And I cited those cases there, and it's at pages 24 through 26 of our brief. Thank you very much.
Can I
Sure.
just, can we just put this to bed in terms of where the scaffolding is? Do you agree that if the post-accident report shows that he was found inside the tower, then we can assume that the scaffolding he was on was inside the tower?
I'm not going to agree with that, because the way that I look at the pictures and the record is this is the tower, okay? Mr. Garcia was working inside the tower. He was working in the upper elevations of the tower, right, where the water would come in, but he was working inside the tower. The scaffolding is on the outside that would connect to a ladder so that he could walk out. And so it was attached.
But if the post-accident report says that he was actually found inside the tower, you're disputing that?
No, I'm not disputing that, Your Honor. What I'm disputing is whether or not he was working on an improvement and the dangerous condition was on an improvement for which he was contracted to renovate, repair, or modify.
So you're saying there's a genuine issue of fact as to whether or not the scaffolding he was on was inside or outside the tower?
No, Your Honor. I'm saying there's a genuine issue of material fact regarding whether or not he was working and injured in a place.
I get that, but whether the scaffolding was inside or outside the tower is irrelevant, is very relevant.
It is very
And
relevant.
so you keep saying it was outside because of a picture, but they're saying he was actually found inside the tower. Is there a way for him to have been outside the tower on the scaffolding, fall 54 feet, and then be found inside the tower?
Your Honor, I'm going to use this box as an example. If he is on scaffolding, and mind you, there would be another unit right next to it, right? In fact, some of the pictures that are in the brief are pictures taken from Unit O looking into Unit P, right? There is scaffolding that connects these two units, okay? So the summary judgment record indicates that he fell and hit additional metals below him, and he landed here, right?
Outside the tower.
Well, it is not outside the tower, like in the parking lot.
Outside the cell he was working.
Outside the cell he was working on, yes.
Okay.
Yes, that is a true statement.
Okay, so we'll go back to the record and look at that.
Yes.
Okay.
And so the record is clear as mud, I will tell you. But what I will tell you is, because we're looking at multiple towers that were next to each other, and there was scaffolding that would connect those tower units together, right? The disrepair of this scaffolding here, he fell here, okay? There is a kind of, not an umbrella like, but there is a structure over these towers. And that's how these individuals were up in the upper elevations making the repairs because of the water and the condensation and whatnot. He did not fall in here. He did fall here, but it was equally near Tower O, and then there would be Tower M and then Tower M. Thank you very much.
Anything else?
This case is going to be submitted. Court is adjourned.
All rise. Thank you so much.